Yes, Miss Gumbel.
May it please your Lordships and my Ladyship. In this case, I appear for both claimants together with my learned friend, Mr Levinson, and the claimant YXA is a protected party represented by the official solicitor.
Yes.
And the defendants are represented by my learned friend, Lord Folkes and Mr Stagg.
Yes. Well, now, we've, just to let you know, we've had an opportunity to read and taken the opportunity to read extensively into this case. We've read the pleadings and we've read the skeleton arguments, and we've dipped into a number of the other documents and the papers, and we've read a number of the authorities.
Thank you, my lord.
Have you had a chance to discuss with all folks the division of time and how long you think we're going to take?
My lord, I would certainly finish today. I would hope probably in the middle of the afternoon, if not before. Obviously, it's always difficult because it depends, not to put too fine a point on it, to some extent as to the amount of intervention and questions and diversions, as it were. But what I'd propose, my lord, is to take your lordships and your ladyship through the authorities in chronological order, rather that they've been helpfully put in the e-bundle and the authorities bundle by my learned friend Mr Stagg, but they've been arranged in alphabetical order, and what I'd proposed was to go through in chronological order because I think it is important to see the history in relation to the authorities, and I hope your lordship and my ladyship have a summary.
And we have reminded ourselves of the history. For my part, I'm not sure it's going to help us to go through it in disagree, in any extensive detail.
What you really want is the facts, the pleadings relating to the current authorities, pool and EFX and STFX is arguably wrong, because that's where we are now in 2022.
Well, it is, but I would want to go back to some of the history because of the fact that the background and the reasons why Ex and Bedfordshire is no longer, the rug having been pulled on the public law issues in Ex and Bedfordshire, does give a background that we say is important.
Well, what I would say, Ms Gumbel, is that obviously we're not going to stop you taking that course up to a point, but first of all, we have taken the trouble to read extensively into the authorities ourselves, and secondly, I think you just do it, if we did that in any detail, we'd be here all week. Obviously, we're not here for a sort of, interesting thing would be to have a legal analysis. In general terms, we're here dealing with these two specific appeals.
Indeed, my lord, and I understand that. I wasn't proposing to go through the authorities in terms of taking your lordships and my ladyship through in detail the facts in the authority, but only to point to specific short passages, which is why I've provided what I hope is a helpful.
But my lord is right. The focus of this appeal is obviously going to be on the application of principles, as they now are, to the facts of this case.
Of course.
These cases.
Of course, and that we have very much
stated the obvious, obviously,
in mind. But in order to see where assumption of responsibility fits, because the issue that has troubled the first instance judges, not only in these two cases but in other cases, is what is that something extra that amounts to assumption of responsibility. And in our submission, it's helpful to look at the background in terms of assumption of responsibility and in terms of where statutory powers, duties and discretion lie in terms of where there can be an assumption of responsibility in the common law context, in order to see where in terms of these cases it could be said arguably, and that's all I need for these appeals, there has been an assumption of responsibility, or there could turn out to be an assumption of responsibility when the facts are investigated at trial. So that was really the context that I say it's important to see what has been said in the past, because that has been a puzzle to the first instance judges and all we've seen so far is that everything that's been suggested as assumption of responsibility has been said not to be. Effectively, there are 2 first instance decisions, I think, where it said, well, it might be arguable, but generally the case in these 2 cases and in the DFX case, it's been said there's no assumption of responsibility.
Okay, all right. Well, after that initial skirmish, let's get going, shall we?
Thank you. I will take it as shortly as I can, but there are passages that I think are helpful to remind your lordships and my lady of. Can I just say right at the beginning, because I know this, I'm not sure there are press present, but that anonymity orders have already been made by Lord Justice Mail in both cases in granting permission to appeal.
Yeah.
And just for the page references of page 18 in the HXA bundle and page 7 in the YXA bundle. And I just say that to remind the court and ask that those are continued.
Yes, we'll continue those
in appeal.
This case being live streamed. Nothing must be said nothing must be said or published to identify either the claimants in this case.
Thank you, my lord. My lord, can I then turn to the document that I handed in this morning, which is the authorities in chronological order. I've called it the map of the authorities, and the references that I say are particularly relevant to these appeals. On the back of that, I've set out, just in order to try and summarise them, what I've called core propositions, which are the way that we put this case, is that the issue is to determine the circumstances in which a local authority or its social workers, for whom it's vicariously liable, owe a duty of care to a child to whom the local authority is providing child protection services. That's how we put the issue. And the consideration of the following questions we say are important in trying to decide that issue. It does involve looking at what is the task of a social worker. Is it confined to providing information to the local authority about children in their area, or does it extend to providing services to the children themselves who are at risk and who require protection? And there are passages in the authorities that I would seek to go to where the views have changed as to whether duties are only owed to an employer or to those who are concerned with the task, both in the education cases and in other public law spheres. So that is an important aspect to which I would point to some passages in the authorities. Then, are social workers professionals whose actions are to be judged by the Bolam test and who will be in breach of duty of care to a child in their actions if they fall below that of a competent social worker? And we say the Bolam test is the way of meeting the arguments that it is such a difficult and finely balanced task often that social workers have to perform. Of course that is right, and of course there is enormous difficulty in the decisions they have to make, but the protection or the way that the courts in cases where there is a duty of care for professionals address that is by how the Bolam test is set by the standards of other social workers, and it does provide considerable protection to professionals that the claimants have to prove that no competent social worker could have acted in the way that a particular social worker has been
That's really
criticised.
breach. We're dealing with a much earlier case, which is what are the factors that show assumption of responsibility. You need to look at the pleadings and see what are the things that are said here to give rise to the duty of care.
Indeed, but in looking at whether the circumstances in which a social worker can assume responsibility, part of the arguments that they don't in these cases and in other cases is the difficulty of the task of social workers. And we say it's important in that context to look at the fact that what is being said is that social workers, when they assume responsibility, will owe a duty of care, but they will be protected, if I can use that term, by the Bowling test in terms of not being liable every time they make a wrong decision. They will have to make a decision that she's out.
Well, as my lord says, B seems to focus on breach. It's C, isn't it? 2C where we're going to be focusing principally in this case.
Yes.
Indeed.
Is that right?
Yes.
But if the route to owing a duty of care to a child is the local authority's social worker assumes responsibility for a particular child, at what stage in the child protection investigation does such an assumption of responsibility occur? The answer that has been given is it's fact sensitive, but the problem with that answer is that one has to have some greater guidance into what can be an assumption of responsibility. Otherwise, one has reached the position, we would say, as we say in the skeleton argument, where all of the main tasks that social workers carry out in the child protection process have been ruled out as not being an assumption of responsibility. And as the judges seem to have said, who have looked at these cases, that it's only Barrett and Enfield and the taking into care that gives rise to an assumption of responsibility. And we ask, in respect of that analysis, well, if that were the case, Lord Reid would have said that. And he didn't. He said there will be cases where there's an assumption of responsibility. The public law barriers, the policy barriers to there being a duty of care set up by Exon Bedfordshire and pulled down by D&E Berkshire and then challenged in CN and Poole in the Court of Appeal have now been clearly swept away, so that one is looking without those policy considerations at where there can be an assumption of
So what I'm looking at this single, you always used to have a single page of propositions.
Thank you, my
Where is the answer to your question you pose at 2C?
Well, what we say is that the policy considerations that the two cases demonstrate the uncertainty in respect of this issue following CN and Poole. But the things that CN and Poole confirmed are that the policy considerations, and I was getting ahead of myself
We
there.
know that. We know the policy doesn't stop it anymore. And there is no point going through lots of authorities that showed what the policy considerations were, because we know they don't apply. The key question is, looking at your pleadings, which facts you say are different from Poole, as applied in DFX, unless DFX is arguably wrong, that show that on the facts of this case, there are pleadings which could lead to an assumption of responsibility. Not a high-level analysis, it's focused on the pleadings.
But what is important, we would say, is to look at that against the background of N and Poole, and not against the background of the cases that have been decided since, because those cases have simply demonstrated a kind of domino effect of looking at particular facts and saying those particular facts have been ruled out, so find us some new facts.
Okay, so you're going to start, so it follows from that, doesn't it? Your analysis starts and ends with N and Poole, because you say everything that's followed on from that is heresy.
Well, it's
My
not
word,
necessarily right as far as...
Potentially heresy. Okay. I don't think, if I may, I don't think you've answered my question. What is your answer to the question at 2C? How would you frame in a sentence or two where the line is drawn? At what stage does, in the child protection investigation, does an assumption of responsibility occur? What do you say is the key point?
Well, what N and Poole tells us is that it's fact sensitive and that you have to look at what the relationship between the particular social workers and that family were on the facts by an analysis of the facts. and decide whether there has been an assumption of responsibility. And we say the only way of doing that, because very little guidance was given in N and Poole because of the particular facts in N and Poole, and I'll come to that, the problem for us as practitioners and for the first instance judges who've looked at that is precisely that there was very little guidance given. So it is very difficult to give a specific answer, and it was specifically not given, as it were, that assumption of responsibility seems to be something that you recognise when you see it, but you can't describe it.
Well, does it follow from that that in every case you can't strike out, and you have to go to a full trial and then decide from the facts whether there is some responsibility, or is it not possible to assess that from the outset? So as
there obviously will be cases that can be struck out if, for example, the local authority had no involvement with the family at all. The not taking on the task would be a strikeout situation. Okay. The reason in N and Poole, and it's perhaps sort of identified by the example they gave of where Lord Reed gave of where an assumption of responsibility might have lain in terms of the email, was but that wasn't written in the context of child protection tasks. And we say rhetorically, well, if it had been written in the context of child protection tasks, that's an example of where there would have been an assumption of responsibility.
Okay, well, okay, if the local authority never come across the child, then I'm prepared to, obviously there's no such responsibility. Now, after that, there's an infinite possibility, the extent to which a local authority may be involved with the family. From one referral from the school up to the point the child's full care order is made. So where do you say the assumption of responsibility line?
Well, we say in any particular case, there may be an assumption of responsibility as soon as the social workers are involved with a particular family, because they are taking on the task of child protection. And an example, we say, where there should be an assumption of responsibility is where a school or a neighbour refers a child because they're worried that there are allegations of sexual abuse. Would the social services investigate? Social services say yes, they will investigate. They visit the family, which is an intrusion into the family as well as an action that entitles at least the children, either implicitly if they're small children or older, if they're older children, in fact, to expect that the social workers are looking into their safety. And if they've made a complaint, and here the allegation in YXA is that the child had made a complaint that her father was touching her breasts, why is she, we would ask, not entitled to expect that social services will look into that responsibly? They do take on the task of looking into it. They do hold a child protection meeting, and what do? They decide that the father's, nothing's known about the father because they're, we would say, negligently not looking at what is known, which they could well have ascertained that he had shaken his own child and been convicted of serious offences. They've taken on that task. She's made a complaint. They've looked at it. They've negligently decided it's not a serious complaint and done nothing about it. And what is the upshot? He rapes her because her complaint at an early stage hasn't been properly looked into. Now,
that sounds like the fact that you have a statutory power or function and you exercise it or consider exercising it because somebody's referred, there's always a duty of care, and presumably, if you negligently don't open the letter of referral, there's similarly a duty of care, but Poole and DFX seem to indicate that that isn't the case, because what you're looking at is whether the authority is liable for damage caused by a third party, the parents and the partner, and there has to be an assumption of responsibility to stop that. And you know, the real question that you've got to address is you've got to take us to the parts of your pleadings, show us that they're different from DFX, or that DFX is arguably wrong, because that's the fullest application and analysis of N and pool to this case.
Well, that's why I say it's necessary to look back at what the authorities help us with in terms of assumption of responsibility and in terms of where taking on tasks in a public law context, there can be a common law duty of care, and parts of X and Bedfordshire are helpful on that.
Okay, well,
I know it's...
I think we need to get on with it. If we're going to go through the authorities, and you can tell we're not going to be comfortable about your going through them in full detail, but if the purpose of this is to help us identify where the assumption of responsibility lies, all well and good. But as you can tell from our intervention so far, we are, sooner or later, very keen to know how you put it on the basis of your pleaded case.
My Lord, I'm very well aware of that. The reason I was going to go to the authorities first is that I think against the background of the passages that I seek to refer to, which are short passages, and I won't be seeking to read them all out, but only to identify them, that it will be easier for me to explain or to ask why isn't that an assumption of responsibility against those authorities and the way that the law is developed in this area.
Okay. Right. Where do we go first?
If I can take what I call the map, and I know many of the passages are very well known, but sometimes it's just worth being reminded of them. What the map does is set out the authorities that are in the two bundles chronologically, and I've set out the page references are both the e-bundle and the bottom of the hard copy bundle, the bottom right-hand corner page references. So I start with Headley Burn, just really as a reminder as to how wide assumption of responsibility can be and how it applies to professionals. So I've started tab 10 with Headley Burn at page 284. I know this is...
Are all these passages in your map marked?
I hope so, but there may be one or two that aren't, I'm afraid. And the marking is marking that doesn't distinguish between our passages and the defendant's passages, which is why I'm seeking to identify the ones that we rely on by that map. I'm sorry it's not maybe ideal to do it in that way, but I thought that it would be helpful to have them chronologically and to have those passages that we're relying on specifically pointed out.
Okay, well, we start off with the well-known passage in Lord Morris's
My Lord, yes.
speech, as it then was in Headley Burn.
And the reason I go to that is to say, reading that, why shouldn't that apply to a social worker who is visiting a child at home, is taking a complaint in relation to a sexual assault and is not dealing with it competently, but is effectively ignoring it for a negligent reason. And that's the starting point in terms of assumption of responsibility. It is a very wide duty.
If that's right, pool would have been differently decided.
Well,
even pool was an example of precisely that. They put them there. They put them in the estate. They were told time and time again the children next door are making their life a misery. And they investigated. So if you're right, pool did a major mistake. You can't just take sentences out of context in one case and say rhetorically, oh look, those words on the page apply to this. You've got to look at the facts of Headley Burn. You've got to bear in mind that when you get to pool, there was a specific context. Otherwise, it's hopeless.
But pool, and this is an important factor, was not a childcare case. And it may be, I have to take responsibility for it, but it was trying to get into the context of child protection, a case that was really about rehousing. And what I was, and I take full responsibility for this, criticised for, suggesting that these children could never have been removed from their mother because this was not a child.
That's not the point that you make with Headley Burn. Your point is the words on the page say if you undertake a responsibility to somebody to do something, thereafter there's liability. And if that's true, it's as true in pool as it is in this case.
Well, it's not that there is always liability, because of course in Headley Burn there wasn't, because they had specifically excluded it. So there will be cases where liability is excluded for other reasons. And in terms of pool, the reason that liability was excluded was that the tasks that they were doing were not child protection tasks, and they hadn't assumed responsibility in terms of child protection. They were looking into complaints about the housing situation of the children in that case, and that is a distinction which it's important, we say, to bear in mind when we come to the facts of CN.
So we did 284, then you've got some more references.
The other references
296
really
and 310.
repeat that, and it may not be necessary to go to those, but I'd just give your lordships and my lady those
Well,
references.
that's Lord Hodgson agreeing, and I
then
imagine
Lord
that's
Devlin.
Lord Devlin also
Yes.
agreeing, is it?
The references in the Home Office, again, I point to them, and we've referred to them in our...
Well, actually, before you go any further, is this where the phrase assumption of responsibility it comes from? Lord Devlin in Headley Burn.
My lord, I think it had been used earlier,
Okay,
but it's
well,
often
maybe, yeah.
dated back to that.
Okay.
But
Anyway, that's where
certainly
there it is in Lord Devlin in 311.
at the bottom of 310 and over on to 311. And all I'm saying is, I think it's helpful to look back at where it comes from, because it's used without very specific. Had Lord Reid said, and in the child protection context, these things will be an assumption of responsibility and these won't, we probably wouldn't all be here trying to grapple with it today. It's because all we really have as a clue is where there's an assumption of responsibility. We're not ruling out a duty of care by social workers to children. So we do have to ask, what is the meaning of assumption of responsibility? What is the context? That's why I'm taking those passages as the starting point. I know they're very well known, and I know in a sense it's not necessary to take your lordships and my lady to them, but that is the context of our case and how we ask the court to approach this. The passages that I've identified in the Home Office and Dorset Yacht are really in terms of what can reasonably be decided on a strikeout application. And again, it's probably not necessary to go to them, and they're well known. But this is a strikeout application. It is always difficult and unsatisfactory in a way to have to decide difficult issues in that way. And 352E is the point is made that all you've got is the facts in the statement of claim, and can they amount to an assumption of responsibility? Not do they, because you may need a trial. So I've just identified there the passages from that, and then I've moved to Exton Bedfordshire, and what I say in terms of Exton Bedfordshire is important, is to look at the history in relation to those cases, and to see, whilst the Court of Appeal decision, the head note sets out the facts which are, and what's perhaps relevant is that the facts in Exton Bedfordshire are very much closer to the facts in this case than the facts in CN and Poole were, because it was truly a child protection case, and it was a case in which children were subject to neglect and abuse at home, and nothing was done about it, and it was known. So I do point to the head note in that respect, and that's why I've given that reference, and the findings at page 825, the fact that the findings in relation to duty of care in breach of common law duty of care were the policy considerations. And then I go back just to show what the situation, in a sense, was without the policy considerations that led the House of Lords to rule out a duty of care, in looking at what Lord Bingham, and then the Master of the Rolls, had said in his dissenting judgment in the Court of Appeal. And you might say, well, it's a dissenting judgment, and why are we looking at that? But it is relevant to how, stripped of the public law considerations, this case was seen in the Court of Appeal. And if I can just go to 854, at letter B to D, which again goes to one of my propositions, which is we have to look at what is the task of social workers, where do they fit in the map of professionals.
I mean, how does this really help us? We've got 2 paragraphs of a dissenting judgment in the Court of Appeal, which has now largely been overtaken by events, telling us how difficult the task of a social worker is. How is that going to help us decide whether all the pleaded facts in the light of pool and DFX? I don't understand what I'm getting out of this that will assist me to resolve this appeal.
Because we would say that, stripped of the public law barriers, this is the correct approach in terms of the role of social workers and why social workers should owe a duty of care and be seen to assume responsibility in the difficult tasks that they do.
So you say that, stripped of the public law barriers, so Thomas Bingham's dissenting judgment.
Sorry, Ms Gumbel, when you refer to public law barriers, do you mean public policy barriers?
I'm sorry, public policy barriers.
Yes, that's what you did say public law.
I'm
I
sorry.
repeated it. Ladies,
Sorry.
public policy.
Public policy barriers.
But then Master of the Rolls is minority dissenting judgment. Somehow acquires a greater status. Just what is that greater status now? And that's the first question. The second, has that fact been acknowledged in any of the authorities that the Bingham OR's judgment has acquired a greater authority in the light of the changes?
It
since
is
Excellent.
quoted later by Lord Brown Wilkinson in the Barrett and Enfield, and he agrees with many of the propositions, but says that it's the public policy barriers that lead him to a different decision.
So we know though that's not right now. We know because of Poole that that's not right. So what we have to look at is, given that there are no public policy barriers now, when you're dealing with a statutory power or regime which could prevent another person harming a child, what gives rise to a duty of care? And at the moment I'm having trouble in understanding how a dissenting judgment of the Court of Appeal in that context, and given that we've had the Supreme Court in end, really helps me. I don't know which bit I'm supposed to be applying to the facts of your case and saying, therefore, you succeed.
Well, why I'm saying it's helpful is that this is looking at what would be the position of social workers absent the public policy barriers, and CN and Poole took away the public policy barriers but gave us very little help in the child protection cases because it wasn't a child protection case. So I'm saying it is helpful to go back to the child protection cases and see what the thinking of the Master of the Rolls and the House of Lords, and I will come to 2 short passages from Lord Brown Wilkinson as well,
In
as to what
Enfield.
the thinking is in the child protection cases.
Okay.
Because we don't have that in.
Well, I think unless my Lord and my Lady disagree, I think it would be probably sufficient if you do, as you have done, identify those passages in Sir Thomas Bingham's dissenting judgment, and without going through it in any detail, because it sounds like Lord Brian Wilkinson is going to be the sort of main hook on which you hang your submission.
My Lord, yes, but I still think it's helpful to see how it was approached in terms of, because we are looking, although CN and Poole has now told us there can be an assumption of responsibility, because we have, we would say, so little guidance on the specifics, we do need to go back to what other judges have thought about the specifics and the role of social workers, because that is the nub of these cases, is should social workers have a responsibility that can be sued.
I mean, I don't want to debate, precedent and the broad principles with you, but what authority does a dissenting judgment, of course, any judgment from Lord Sir Thomas Bingham carries authority in one sense, but in every sense. But strictly, how does a dissenting judgment, way back in time, before the mists cleared, following the later authorities, how does that help us?
Because all of this territory is about what judges consider is the right answer to should social workers be able to be sued for not carrying out their child protection duties.
That isn't the question, though. We know the answer is you cannot generally be sued for failing to exercise a statutory power which would have protected somebody. The question is, what factors in that context amount to an assumption of responsibility? And Sir Thomas Bingham wasn't dealing with that, and I don't know whether the other two found that there wasn't a duty of care, or whether there would be a duty of care, but for public policy factors. Because if it's the latter, if they say that there's no duty of care, then the majority is more relevant than the minority. But in any event, you're dealing with an historical target, not the current target. Surely you accept that you have lost the main argument that the exercise of statutory responsibility, which could save somebody from the harm caused by a third party, is not of itself enough to establish responsibility. So if that is what Sir Thomas is saying, that is inconsistent with Poole.
Well, we would say it isn't inconsistent with Poole if the answer to Poole is that is in the housing context, not in the child protection context. He was not looking at a child protection context case. And the Poole decision was that if an email saying we realise we've not carried out our duty was in the context, or that you don't think we've carried out our duty was in the context of the Children Act, it would be different.
Are you saying then that Poole is simply to deal with the housing context, and it is still open to this court and any court to say that there is a general duty of care owed in respect of the exercise or non-exercise of statutory powers under Section 17 and 47 of the Children's Act?
No, because Lord Reid did say that it was not that Exon Bedfordshire, because we needed the Supreme Court finally to dispense with, as it were, the Exon Bedfordshire, because although the Court of Appeal had done so in East Berkshire, when the Court of Appeal looked at that position in CN and Poole, they thought that Exon Bedfordshire was still good law and that East Berkshire hadn't really been entitled to sidestep Exon Bedfordshire, whereas Lord Reid and the rest of the Supreme Court in CN and Poole did sweep away the public policy considerations in Exon Bedfordshire.
They did two things. They swept away the public policy considerations, but didn't they also say that there is no general liability for failure to exercise powers under Section 17 or 47, where that would have prevented somebody harming a child, unless there was an element of assumption of responsibility or one of the other factors? And if that is right, what's the purpose of relying on Sir Thomas? Because he wasn't dealing with that question, was he?
Because what we're looking at then is, in the context of child protection, what steps that social workers take are an assumption of responsibility, for which we say we have very little help from CN and Poole, And that's what we're looking for, is what historically has been thought to be something that would give rise to a duty and would be in, you would expect to have a remedy. And what we're looking at is, where is there a remedy on the basis of assumption of responsibility and reliance? And the defendant's argument is, never in any of these contexts until a child is taken into care. Lord Reid did not say Barrett is the start of an assumption of responsibility. He said you have to look for an assumption of responsibility on the particular facts. We have particular facts which we would say are particularly stark in relation to child protection steps, and we're looking back at what, very well respected judges have thought should be the position in relation to social workers carrying out child protection tasks. And we think it's helpful that Lord Bingham said at C to D on page 856, if the County Council...
Yeah. That is the kernel of what is relevant for us, if anything is relevant for us in this judgment. It's those 3 or 4 sentences at the end of that first paragraph on 856.
My Lord, yes. And it's just that we say that was, as far back as 1995, the position taken, but it didn't, the claims didn't succeed because of the public policy considerations.
What did the other 2 judges in the Court of Appeal say? Did they say they agreed with Lord...
No.
So the majority didn't accept that there was
No.
a duty of care even without the public policy consideration?
No.
The majority was against that submission.
My Lord, yes. And but more importantly, so was the House of Lords, apart from a dissent. There was one dissenting judgment in the House of Lords.
Well,
Lord Nolan, yeah.
Can we just be clear if you're agreeing, my Lord? Because there we have Lord Bingham defining, Sir Thomas Bingham as he then was, defining what the duty was in the absence of public policy considerations, which he thought didn't apply, correct?
Yes.
If other judges, particularly in the House of Lords, as the Lord says, if the other judges in the Court of Appeal disagreed with what he said about the extent of the duty, irrespective of the public policy considerations, then, as my Lord says, why don't those dicta carry greater weight than his minority view?
Well, none of the decisions in Exon Bedfordshire are now binding because they have been overruled by Enham Pool through D and East Berkshire.
Exon Bedfordshire being completely overruled.
Well, it's been overruled to the extent that there are public policy considerations.
So the rest of it survives, doesn't it? I mean, I'm being crude here. I know I'm oversimplifying this, Gumbel, but you see our concern, or my concern. I think my Lord shares it.
Yes.
That if we excise the public policy point from Exon Bedfordshire, it doesn't follow that everything that was said by all the judges carries weight, does it?
No,
we have to analyse it more carefully than that.
Can I also ask you a question, please, Ms. Campbell? Does Sir Thomas Bingham, in this dissenting judgment in the Court of Appeal, ask the question that Lord Reid has now told us we need to ask? In other words, does he ask the question, was there an assumption of responsibility?
No.
Right, well then whatever the status of this judgment, I'm at the moment struggling to see how it helps us at all.
Well, it helps in terms of the approach to...
No, it doesn't. You've just told us it doesn't, because you've just told us it doesn't ask the question of the assumption of responsibility.
But that is narrow. But what we're looking for is help with answering the assumption of responsibility question.
But how do we get help about answering that question from someone who hasn't asked the question himself or answered it?
Well, because it is a very broad issue as to where is there an assumption of responsibility by social workers and in other cases, and in Exham Bedfordshire, what was said is the role of social workers is so difficult and finely balanced, and you can't have a duty.
That isn't what the case is about now. That's gone. This question is about how far does N and pool apply to a different context, child protection, and in particular, given the DFX tells us how far it's gone, is that arguably wrong? So it should be argued in another case. But you're not looking at the current problem or the current fact. You're looking at something quite different 30 years ago.
Well, I'm trying to see how the law is developed in terms of the role, because what we're looking at is social services liability.
Are you saying, focusing on 856, I don't want to do this with all the authorities, but as we're looking at this one under the microscope, are you saying that in answering the question, the lady's question, where is the assumption, the question which Lady identifies from Paul rightly, where is the line for the assumption of responsibility? We can rely on what Sir Thomas Bingham said, which was the duty must have embraced the duty to take reasonable care to protect the children against sources of harm of which, on the facts pleaded, the County Council was very well aware by taking such steps as were justified to move them out of harm's way. Are you saying that's, so there was this, where the local authority was very well aware of sources of harm to a child, that is the point at which there's an assumption of responsibility?
My Lord, we are saying if you turn it into a question of assumptions, which was not the way it was looked at the time, and obviously Lord Reid has said that the Emma Newham case, which was looked at as an assumption of responsibility, shouldn't have been, because where the local authority causes the harm, you don't need assumption of responsibility. The terminology and the analysis has changed through these cases.
No, I'm trying to just pinpoint, and I know it's me being slow, Miss Campbell, so forgive me. I'm trying to pinpoint what it is in Sir Thomas's reasoning that you say helps us on defining the line at which responsibility is assumed. Have I got it right that you're saying it's where the local authority is very well aware of the sources of harm?
My Lord, yes. And it isn't stated in terms of assumption of responsibility, but if you ask rhetorically, would that be an assumption of responsibility?
I don't ask it rhetorically. I ask it, whatever the opposite of rhetorically is. I ask it
But how can awareness of a risk equate to an assumption of responsibility? Isn't there a gap?
Well, it will depend on further factors. They become aware of it. Have they agreed to look into it? Might well be an issue. But if they are aware of it, they will, as social services, they will be generally made aware of it in order to look into it. And unless they say they're not going to look into it, I would say, why isn't there an assumption of responsibility in terms of investigating?
Well, because of the
known
But it sounds like there's a shirking of responsibility.
I mean, the problem you've got pool, and whether one likes pool or not, it says that Section 17 and Section 47 do not themselves generate a public law duty of care. There's got to be an assumption of responsibility, and it's pretty clear from the case itself. In that context, investigation and monitoring isn't enough. You've then got DFX, which has specific facts, and assuming your pleaded case comes within those facts, the question is whether or not that is arguably wrong. But I still don't understand why you aren't showing us the facts of your case and why you aren't saying they're different from DFX or DFX is wrong. I don't understand why you're ignoring all the recent cases to deal with a case and a dissenting judgment which wasn't on point.
I'm trying to grapple with what can be an assumption of responsibility in the context of social work responsibilities when we have so little guidance from N and Poole as to what is and what isn't.
All right.
And where it has been assumed, because Section 17 and Section 47 investigations of themselves in the context of a rehousing case have been said not to be, can one therefore just latch on to that and say they never can be?
All right.
Say
Well,
no.
okay. Well, let's moving along. Have we finished with
My Lord, yes.
X and Beverage? Do you want to take us to anything in the House of Lords next?
My Lord, yes. Just because this meets what we would say is perhaps an oversimplification in some of the cases as to what is statutory discretion. Lord Brown Wilkinson at page 923 sets out very coherently, and nobody has ever said that this is anything other than a coherent analysis of where a common law duty of care can exist and where there's a coexistence of a statutory duty and common law duty of care. And what I particularly point to is the example at the bottom of page 923, because as I understand some of the arguments my learned friends make is that this is all has to be outside statutory discretion, and the example there of in the educational field that a statutory discretion would be the discretion to close a school, but the actual running of a school pursuant to statutory duties would, in the right circumstances, give rights to a common law duty of care. And I think that's the best answer to what's the difference between where there are statutory duties and statutory discretions. That the example that I always bring to mind is the running of a school. If you close a school, that's a statutory discretion that is not challengeable unless it's outside the ambit of discretion. But once you have taken on the task of running it, there can be a common law duty in relation to what happens within the school.
But isn't that a point that's against you? Because if you translate that principle into a decision whether or not to institute care proceedings, you're on the wrong side of the line that's drawn there by Lord Brown Wilkinson, aren't you?
No, we would say that isn't where you draw the line, because if it was where you draw the line, then Lord Reid would have said Barrett and Enfield is the only circumstance in which, in the social services context, there can be a duty when you've assumed responsibility for a child by taking them into care. And that's clearly what he didn't say, is that it's only on taking a child into care that you've assumed responsibility.
No. All right. Well, no doubt you're going to tell us, in due course, where you say the line is drawn. But you want to do it by reference to the authorities. So have we finished with X and Bedfordshire?
The only other passage in X and Bedfordshire that I refer to is 937D. And that's the fact that the requirements, I mean, it's really just identifying that it is the public law considerations that ruled out there being a duty of care. There were not other reasons why a duty of care shouldn't be owed, and those are the passages, but they are well known. But what I would point to is on page 941, letter E, which we do say is now different in a modern context. And I will point to the passages in Phelps that make that clear. In my judgment, in the present case, the social workers and the psychiatrists did not, by accepting the instructions of the local authority, assume any general professional duty of care to the plaintiff.
Forgive me, where are you reading from?
I'm sorry, 941E.
My fault. Thank you. Yes, got it.
The professionals were employed or retained to advise the local authority. And that is saying, as I understand it, at the time, that social workers would never assume responsibility for the child because their duties were only to the local authority. And we say that is a concept that is overtaken by the more modern authorities, and that the idea that the child is only the subject of the investigation but not someone to whom a duty can be owed is overtaken by the authorities, and certainly by CN and Poole, because there can be assumption of responsibility in relation to the child, despite
there may
being
be circumstances in which an assumption of responsibility may arise, but isn't this saying, and is it still binding on us, that the fact that they're social workers and the fact that they're doing things on the instructions of the local authority doesn't involve an assumption of duty, i.e. merely being social workers and doing what social workers do isn't enough, or is it not saying that?
Well, I understand it to be saying that social workers only owe duties to their employers and not to those for whom they are making decisions, and that is a concept which is no longer...
Well, no, it's because they're retained to advise the authority and they're not advising the claimant. That's the point. When you get to reliance and so on, it's like the Rayside report in DFX. That was done by the authority through the professionals to inform itself, and it doesn't give rise of itself to factors that generate liability. So if you're relying on the judgment of the dissenting judgment of Sir Thomas, in spades, the mere fact that social workers are doing things for the local authority wouldn't amount to the kind of factors generating responsibility, would it?
Well, we would say that can't be right as a general proposition, and is not right if there are any circumstances in which there can be an... If that were still the correct statement of the law, that the social workers can only owe a duty to their employers, never
No,
to...
that's not what I'm saying. I'm saying something quite different, Miss Gumbel, which is this, and it's precise. The fact that you have social workers doing things because the authority asks them to do things in relation to children does not amount to an assumption of responsibility, because they are not providing a service to the children that are being relied on by the children. It's being done by the authorities or the discharge of their functions.
But that doesn't prevent, in the modern view of what social workers do, including what was said in N and Poole on social workers in particular circumstances, owing duties to children when they assume responsibility for the tasks in respect of individual children. Whereas if this were always true, then Lord Reid would be wrong to say that there are circumstances in which there can be an assumption of responsibility. Because if they are only ever doing their tasks for their employers, then there would never be circumstances in which they could assume responsibility to the subject of their investigation, which is the child. And therefore...
Right, have we now completed X and Bedfordshire?
My lord, yes.
Okay.
My lady.
Are we going to Barrett and Enfield next?
Barrett and Enfield is really just to point out that that was a rowing back from the X and Bedfordshire position. The context of Barrett and Enfield was that X and Bedfordshire has gone to the European Commission but not the European Court, and the European Commission had awarded damages against the government, but the X and Bedfordshire decision in the European Court didn't come until much later on, and that just explains why there are references to the European Court and the European decision and the human rights position to why there were different considerations now, and that the law had moved on. And it's in Barrett and Enfield that Lord Slynn quotes Lord Bingham in X and Bedfordshire.
Yes, in a passage marked on 76.
My lord, yes. So that I've just pointed to that as to, because we do see this as a moving on of the law in this area, which has always been very difficult to analyse where the line should be drawn and what was.
Now, Barrett and Enfield is still binding authority for the proposition, isn't it? That a child who's been taken into care has a duty of care is owed.
My lord, yes.
Yes.
And that's the answer in N and Poole to the defendant's argument that you can never owe a duty against the statutory backdrop of the duties in relation to social services. There can be duties, as there were found to be in Barrett and Enfield.
To a child that you've taken into care.
My lord, yes.
That's all we know from it.
That is where the law had got to in 1999.
Is anything said in Barrett and Enfield, Miss Campbell, about whether there's a distinction between a child who is the subject of a care order and a child who's being looked after by the local authority but not subject to a care order?
My lord, not as I don't think that was an issue that arose.
Thank you.
Was,
So that's not mentioned. That's not mentioned at all
in terms
this.
of Section 20 proceedings. But
So all we know about this, and it's only going to help us with one set of circumstances, a child taken into care. It doesn't tell us anything one way or the other about a Section 20 accommodated child or Section 1747 investigation. It just doesn't say anything about it.
I don't know. It deals with because Barrett and Enfield, although I should point out, I think the permission to appeal, Lord Justice Mayles referred to Barrett and Enfield in a slightly different way, which we would say
This isn't going to help us solve this appeal in this case.
Well, it's a moving on by many of the same court from Exton Bedfordshire in terms of where social services.
I understand it's a moving on, but as I understand it, it doesn't say anything one way or the other about the two issues in this case, which is the Section 20 accommodated child and the Section 1747 services investigation. It just doesn't deal with it, so it doesn't help us.
My lord, in that narrow sense, it doesn't help. We would say it helps in sense of the thinking in terms of whether having in Exton Bedford, it was very significant at the time because in
terms of the law of stare decisis and deciding the appeal, it doesn't help us.
My lord, it doesn't help on the particular facts of this case.
Is there any reference in Barrett and Enfield to the specific statutory duties owed to a child in care?
No,
Okay.
it's not. It's more in terms of comparison with parental duties and the fact that there can be duties owed by parents and there can be and it was a strikeout application and it didn't actually decide what it left open that many of the allegations in relation to where there was a duty, even with a child in care, still needed to be decided at trial. So it only decided it was arguable that some of the things that social workers did for children who were in care were justiciable. That's all it really decided.
Yeah. So when we read it, it's not going to help us in this case.
It doesn't help, but it does set the background. Kenton Griffiths was a case in which there were two arguments. One, whether the ambulance authority overall was in the camp of medical professionals and owed a duty of care in any event, but it did also give an example of an assumption of responsibility, and that is at least in a different context an assumption of responsibility, finding the assumption of responsibility, which was that where a doctor called for an ambulance and an ambulance said it would come and then delayed, there had been an assumption of responsibility and reliance. And we would say that would be helpful in terms of where there is a complaint in relation to abuse of a child and the social services agree to investigate that complaint and simply do nothing, is different from the position where they have a duty to look after children in the community, which might be the duty of ambulances to go to a crash, and there was a distinction drawn between the assumption of responsibility on an individual call to an individual where they are appraised of the particular circumstances and agree to go, and that parallel could be drawn with assumption of responsibility in terms of specific investigation of a child who has made a complaint in relation to child abuse. So,
Well, are you going to just highlight precisely, without reading it,
the
which of the marked passages in Kent and Griffiths you say help us on the assumption of responsibility point?
my lord, yes, tab 13. Sorry,
We've all got it. Well, I've got it.
take them.
We're all looking at it.
6 and 7.
I see Mr. Mumford.
6 and 7, page 434.
434.
Are the facts giving rise?
Yes. No. Okay.
And then 37. Is drawing the distinction where the bottom of page 442 see to H the distinction between general responsibilities in running a service and the focused attention to a particular individual, which was a problem raised by the defendants in Kent and Griffiths, and the distinction was drawn in relation to the assumption of responsibility. But in the end, the case was also decided on the fact that there should be a duty because the ambulance service was equivalent to medical.
Can I cut across you? Forgive me, Ms. Gamble. I think it might be the top of 446, paragraph 49, that looks like the point where Lord Wolfe says what we're looking for. The acceptance of the call, in this case, established the duty of care.
Oh, yes, but that was one basis of the finding, and that's the one that's helpful in terms of these cases.
I haven't read this authority, but again it sounds as though Lord Wolfe isn't analysing it in the way that we now know we should be analysing it.
Well,
because he's not referring to an assumption of responsibility.
well, he is referring to assumption of responsibility.
Well, he doesn't use those terms, does he? Without doing a word search.
I mean, I said I've fessed up to the fact I haven't read this authority, but does he use the analysis that we now know we should apply to these cases? Because if he doesn't, I'm not entirely sure how it helps.
I think you're saying that the acceptance of the call was the point at which a responsibility was assumed.
And reliance was of the doc, and one sort of point of some significance is that the reliance was obviously not the patient herself, but the doctor who made the call on behalf of the patient relied on the ambulance coming and would otherwise have taken her own car or got her husband to drive her to hospital. So that was the reliance.
Okay. So we go now to Phelps. You were taking us to Phelps, are you?
My lord, yes, that's...
That's left blank in my tab.
Oh,
16.
But it's 8 on your map, is it not a date? Oh, it's a tab 16.
sorry,
It's
8 in the map.
The map.
The map is a...
sorry, I'm just trying to help with the order. This, we say, deals with the issue that even though educational professionals are employed by the local authority, they still can owe duties to the individuals, which is what we say Lord Graham Wilkinson said was not the case in relation to social services. And it would be very curious if there should still be that distinction, because here Lord Slynn on page 572 is pointing out that in relation to children, the duty can be owed both to the child and to the local authority.
I thought that when this case went to trial, but I may be misremembering, that in fact it was found as the fact that it proceeded on a false premise, and it was thought that the educational services were provided to the parents and was relied on, but in fact that wasn't the case, or have I completely misremembered
I
that?
think, and my own friend will know much better than I, because he was involved in the education cases, I think, or in this case, but I think the reference in Barrett was to the education cases that had been decided with Exon Bedfordshire to Dorset and Hampshire, and I can find the reference, I'm sorry. But
I don't know whether it would help at all if I just intervened on this point. The argument before the Court of Appeal in Phelps, or one of the reasons why it was argued there was no duty of care, was because the educational psychologist was employed by the local educational authority. Ergo, there was no duty owed to the individual. The House of Lords didn't like that argument and decided that actually this was much more equivalent to consulting a doctor, as you might do in the NHS.
Then didn't it go, when it was actually argued, didn't they find that, or am I just misremembering the history, that in fact when it was argued out, it was found that they hadn't provided services on which the parents relied?
I think your lordship's referring to Barrett and Enfield, when
right.
Don't worry, if that's not right, then ignore it.
sorry, tab 5 in Barrett.
Just ignore it, it looks like it's a red herring. I wouldn't spend time on something that I've half remembered from 2 decades ago. I didn't know what I had for breakfast, so I really wouldn't worry about that.
All right, so let's stick at Phelps on 572. Is that the passage you rely on?
My lord, yes.
And is that the passage?
Professional services is part of the fullness. Whether
That's the
any
passage at which Lord Slynn explained the decision which Lord Fawkes has just explained to us.
and
right?
suggest that it would be for the local authority to prove that there wasn't any liability to the individual. That's at letter F, and that it would be unusual if they would be able to do that. And then again, on page 573, between letters B and C, the point is made again in relation to...
Okay.
All I'm saying is that we would say meets blanket proposition of Lord Brown Wilkinson that being employed by the authority rules out liability also being owed to the subject. If it isn't so in the education context, why should it not also be so in the social work context?
Well, the argument might be that a psychologist is carrying out a separate, discrete function in terms of assessing or analysing the child, whereas a social worker is responsible on a day-to-day basis for carrying out the local authority's agreed plan agreed at a case conference or by some other method.
Well, in the context of an individual child and whether anything should be done about a complaint of sexual abuse by the father, which is the YXA case of a complaint that a father had touched the breast, that's an investigation for the purposes of that individual child, to keep that individual child safe from a known danger.
And does that, local authorities employ a wide range of people to deal with these cases? It employs people with qualifications like social workers and people with fewer qualifications like family support workers. Does the duty arise in respect of all local authority employees within the social services department?
Well, it will depend on the facts, rather as in Darnley, the health authority was liable for a receptionist telling a patient that they had a 5-hour wait and they left the hospital, and
So
the argument...
The answer is it may do.
It may do, depending on the facts. The status of the person is not relevant if there is vicarious liability. It depends what you ask them to do and what they take on, what tasks they take on to do. And it would be... And one of the things that we say is comparable to providing a service that the educational psychologist provided is providing the keeping safe work, which is specifically done.
Yes.
And that's one of the allegations again.
Yes. That's part of the facts about which,
which
we're anxious to come to.
I'm sorry.
When you've finished with your map. So we've now got to. Are you going to take us to X in the UK and Europe?
Z in the UK.
I mean Z in the UK. And Europe.
It's really just where it comes in the chronology that it comes after all those cases that there was under the Human Rights Act a duty, and there were some comments in relation to the way that the Exon Bedfordshire decision sits with the Human Rights Act, which become relevant to the East D and East Berkshire decision. There are really only 2 paragraphs which are important in the D and East Berkshire, or two passages. The departure from Exon Bedfordshire was in 2 stages in the judgment, and it's important to see it as such, I think. Paragraph 49, at the bottom, page 1348, sorry, where the judgments start to have paragraphs, I've tried to put the paragraphs as well.
Is this the case where they got the wrong, the child had said something about a named person and they thought it was the parent, the mother's current partner, but it wasn't?
No, that was Emma Newham, which is the case that was heard with... That was the case of the psychiatrist was Emma Newham.
Is that one of the Exon Bedfordshire cases?
Which was heard with Exon Bedfordshire.
So what are the facts? It's quite important to read the facts, because of the way that all works, we look at the facts and the principles decide the facts rather than taking something out of context. What briefly were the facts then?
These were children, your Worship is right, they were children taken into care who shouldn't have been, but it was brittle bone disease and other
okay.
illnesses.
But they were taken into care, and the parents were suing, and also in one case the child was suing, saying they shouldn't have been taken into care.
My lord, yes.
Right.
But what was said about Exon Bedfordshire was not in terms confined to that, and hasn't been confined to that by the CN pool. At page 134, letter H, the effect of the decisions, there's a trawl through the decisions, and the effect of the decisions up until the time of D&E's Berkshire is summarised in paragraph 49, which was these decisions significantly restrict the effect of the Bedfordshire cases, and those included the Barrett and Enfield and Phelps. But what is said at letter B on page 135, the effect of Barrett's case and the other decisions that we've considered is to restrict the effect of the Bedfordshire cases to that core proposition, which is the proposition that the decision whether or not to take a child into care was not reviewable by way of a claim in negligence. And again, if that's where it stopped, we wouldn't be here today. But it's not where it stopped, because it went, the further decision in that case at 82 to paragraphs 82 to 85, page 144, was that even the core proposition in Exon Bedfordshire cannot survive the Human Rights Act. And that has become the controversial proposition in D&E's Berkshire, which was used in the Michael case to try and say, well, you follow the Human Rights Act in other areas of duty of care. But what was said clearly here was even the core proposition that survived the other cases should now go. And what was argued in CN and Poole in the Court of Appeal was that D&E's Berkshire was wrongly decided because the Court of Appeal couldn't overrule Exon Bedfordshire. And that was why in CN and Poole it was for the Supreme Court to address whether D&E's Berkshire was good law and whether Exon Bedfordshire remained good law and survived D&E's Berkshire. And it is an unusual set of circumstances in terms of precedent. But
is it paragraph 84 and 85 we want to look at?
Those are the...
There's no absolute rule saying that you can't owe a duty of care to a child in relation to the investigation of suspected abuse and the initial and pursuit of care proceedings. It is possible that there may be factual situations, yes. And isn't the question that we have to deal in this case is this one of those?
Exactly.
Yes.
But it is, until that point, it was never the case. You couldn't bring a case in relation to whatever the facts. After D&E's Berkshire, you could, and it was not until CN and Poole that
we've got a framework to assess whether this is one of those cases where you can bring it.
But as we are saying, it opened the door, but it didn't define the rooms, as it were.
Exactly.
And that's what we're here to try and do, as Your Lordship keeps reminding me. And I'm sorry, I'm coming to the facts very soon, but I'm just trying to set how this developed. there is one passage in Gorringe, because Gorringe is often cited as a case ruling out duty of care, but it is relevant that the position of children in terms of claims against local authorities is distinguished from the highway cases. There's only one very short passage at 244 between E and F in the speech of Lord Brown. In relation to duty of care. Gorringe being a highways case, because the common law duty of care in these cases found or suggested to have arisen not by reference to the essence of the respective authorities' summary powers and duties, rather from the relationship in fact created between those authorities and the children for whom in differing ways they had assumed responsibility. I would add, moreover, the further distinction, unless in those cases the court were to find the authorities' various responsibilities capable of giving rise to a common law duty of care, those wronged children themselves, wholly blameless, would go uncompensated. However inadequately, their interests had been safeguarded. In the highway context, by contrast, the claimant or some other road user will almost inevitably be at fault. And it was just recognising the distinction between cases where the public authority liability is one of many authority liabilities and one where children have no other remedy.
I mean, you said that Gorringe decided, as it were, against your case, and that's the passage, is it, which was marked at 22, which Lord Fawkes would rely on. Is that right?
But I do just point to that distinction was recognised in the context of that case.
Well, it was recognised by Lord Brown.
Well, I've just been checking, and Lord Scott agreed with Lord Brown's speech, and so did Lord Roger. So
They all do, but it is an obiter dicta.
It is an
It wasn't
obiter
the
dicta.
issue in the case.
Yeah, exactly.
Paragraph 100, you rely on,
Yep.
in Lord Brown. That was his judgment was agreed, was by the others. But it's do you want to say anything about the passages that are taken against you in Gorringe at this stage, or not?
My Lord, perhaps I can come back to those if...
In reply, okay, right.
Blewett is only there as an example of where, after Barrett and Enfield and before CN and Poole, a duty of care was found arguably to be owed to a child who was not in care, where there was an assumption of responsibility in finding, and again it was a strikeout and it was only arguable, but it is another example of where this court has found there's arguably an assumption of responsibility in relation to a child who was not in care but whose social services had responsibility for. That's at tab 6.
So was she being helped under the leaving care provisions?
My lady, I don't think she had been in care.
Right, so she was somehow or other, it came about that she was helped to find accommodation by a social worker.
Yes, she was.
It's not a question of whether or not there are abstract circumstances in which a duty can be owed. We have to look at the facts. It's quite helpful to know what the facts were in Blewett to give rise to the liability, because those may be the same as your case, or they may be very different from your case. So it's quite important to know those facts, isn't it?
Yes, well, the head note sets that out. following a prolonged. She was age 16, suffered injuries when she jumped out of a window in a hospital she'd been placed in.
So facts are in 11. There were problems between the woman and her parents, and there was a voluntary accommodation agreement made. Implication is of which the authority was a party, it is not clear. And that allowed Suffolk County Council to provide her with accommodation, whilst her parents retained responsibility.
Oh yes, so she was not a child in care.
Yes. So she was being accommodated.
And
She was a looked after child.
the way in which they describe assumption of responsibility on page 108 in paragraph 29, little difficulty for present purposes in seeing that Mr. Page assumed a responsibility to Jennifer in the matter of her accommodation at the foyer. Generally speaking, he had a responsibility to take care to see the foyer was a suitable place for Jennifer. To that extent, in the ambit of that responsibility, which is the nub of this appeal.
So where are you reading from?
29 or 108.
29.
Is that, again, without doing a word search, is that the first time the concept of the phrase assumed responsibility is mentioned in this judgment?
In this
Anybody with electronic authorities might be able to help us.
It starts at paragraph 28 then.
Yeah.
Mr. Page had been her social worker for some time, and the Social Services Department had been involved with Jennifer's welfare. He continued to give her help and advice. He was instrumental in withdrawing her from one hostel, and then he put her in, or essentially involved in the choice to put her in another hostel, and that's the one where there were inadequate arrangements and she was able to jump out. So he was involved in the choice of hostel for her.
My Lord, yes.
Paragraph 27, the phrase assumed responsibility appears.
She relied, so she actually consciously relied on him to help her find somewhere to go and live, given the problems with her parents.
Yeah.
My Lord, yes, but this is a child who is not in care, and the argument against us seems to be that it's not until a child is in care.
Yeah, but that's not the point, because paragraph 31 in margin, therefore, the first set of question is whether Jennifer had any real prospect of establishing a trial that Mr. Page knew or ought to have known that the foyer was an establishment at which a young woman such as Jennifer was in significant risk. That was the allegation of negligence. So if you put somebody in a hostel and you know there are people there who are going to damage the person you put in a hostel, the argument is that there may be a duty of care there. You shouldn't have picked that hostel, you should have picked another hostel.
My Lord, yes, but we would say if you know that a child is being sexually assaulted by her father and you let her stay in her father's household, knowing that he has, and you ought to know that he has a conviction for having shaken his own child on a previous occasion, that you ought to know that that child is at risk in that situation.
The difference is that they haven't put her with the child, that's where she lives. In this case, it will be said against you, he was instrumental in saying, this is the place you'll go to, this will be all right, you're looking to me for help, the foyer is the place, and of course, it wasn't the place. That would be what's said against you.
But you are in a position where you've been asked to investigate an abuse by the father, whether the nature of the investigation must be whether the child is safe in a home with a father who has convictions for abuse of children, and you negligently don't recognise that. And I think it would be uncontroversial that if you had, you would have removed her, and the only reason you didn't remove her was that you negligently didn't recognise his convictions. So leaving there can't be an absolute line between leaving somebody in a home that is dangerous and putting them in a home that is dangerous.
Is it just me, or has everybody got a page missing from the bundle
Oh, I'm sorry.
at between 106, can't read, 106 and 107. 106 is page 96 of the reports, and 107 is page 98 in my bundle. Well, it's just me.
My lord, that is correct. It rather appears that when I asked one of the libraries to print this for me and paid them for it, that they didn't print a copy of everything, so I apologise.
I notice you're not assuming responsibility.
Well, I did.
I'm going to. I'm going to.
Out serving her claim for me in due course.
Over the adjournment, I shall think about the position.
And we were all
Mr.
relying on him.
But actually, levity aside, you'll note what is this authority that's being quoted at the top of page 107, because there I see above letter B assumed responsibility. Somebody's saying, it's often a very helpful guide, particularly, to have asked whether the defendant is to be taken to assume responsibility. So that looks as maybe the first time that little phrase appears tantalising because of Mr. Stagg's
Complete your responsibility.
because there is
Investigate.
because of Mr.
My lord, I'm looking at the Bailey report. It's paragraph 25, and that's a reference to the case of Sandar, decided in 2004 in this court.
That was wasn't that the lady whose husband was killed in the car crash?
Yes, it's a highways case, yes.
Well done. Don't worry, Mr. Stagg. Don't. I'm teasing you. We'll get that page over. Anyway, that's probably as far as we can take it without that page. Is that all we need to say on Blewett?
But that's your best case for analogy to your other case too, isn't it, Miss Campbell? Because you can say, okay, in the XYA case, he was only there for a particular time, but they knew they had to keep him safe, and that's why they were putting him in respite care. And you will want to say, I'm sure it's not very far from that, to say, and they shouldn't put him back in a place where he's not getting appropriate care. So you would say, although Blewett isn't directly on point, you would want to say it leaves open the possibility for that case at least of it being closely analogous.
My lord, yes. In terms of both cases, there's similarities in terms, or it is the first case after D&E's Berkshire where a child not in care there is found to be an assumption of responsibility or a duty of care. But at the time, it wasn't necessary to make that distinction, but that happens to be the way in which it was described. So it is helpful, we would say, to look at that. As we have so few examples of assumption of responsibility in terms of social services, we've been trying to find where we can get help from the cases.
But I suppose it could be said against you, Ms Gamble, that this is a case where the social worker took a positive step, namely helping with the placement in the hostel, rather than failing to do something. So it's on the... it's not on the omission side of the line drawn in Poole.
Well, we would say it is a case where the cause of the harm was actually the young woman jumping from the window, not the social worker didn't actually cause the harm. They failed to prevent her from being in a place where she could harm herself.
Well, it was more, I think it's rather, they put her in a place where she didn't jump out of the window spontaneously. She jumped out of the window because a whole gang of people were breaking into her room. So she jumped out of the window to escape from them.
They put her in an unsuitable hostel, is what is said to be.
But the cause of the harm was not specifically
I see the way.
worker.
Yes, no, I see the way.
It was third parties and the young woman herself. They failed to protect her by placing her somewhere that was a safer environment, and that we would say is the same as failing to protect children by placing them in homes other than where they're being abused. It's quite difficult to, and that it does illustrate the difference between the causing the harm and saving you from the harm.
Yes.
This is really truly on the cusp, by the way.
So
isn't it?
it could be said, I suppose, it illustrates the difficulty of identifying whether there has been an assumption of responsibility at the strikeout phase.
My lord, yes.
Stage. Because you say this is a proposition, authoritative proposition, that an assumption of responsibility doesn't have the bright line of the care order. You say
Exactly.
there can be an assumption of responsibility at an earlier stage in local authorities' involvement.
Exactly, my lord. You need to know the details of who said what to whom, which we don't have in this case or any of the other strikeout cases, and the details of conversations in order to see whether there has or hasn't been assumption of responsibility and reliance. And some of it may, in some cases, rely on what was said to an informer who rings social services and says, I'm really worried about this child. She's coming to school with these terrible bruises every morning. What can we do about it? And they say, well, of course we'll investigate. It's our job to see that she's safe. We'll go and visit. We'll do what we can. And they go and visit and say, well, I'm frightened of the father. I'm not going to do anything. Can that really be said not to be an assumption of responsibility? And the reliance is both on the informer, as it was in Kent and Griffiths, and the child, who must implicitly rely on a social worker who's visiting, looking into the facts of the case. What is the child, why is the child not relying on them doing that responsibly? Of course, they're not necessarily specifically relying, because there may be a baby, or they may not know what's going on. They may have learning disabilities, but there must be an implicit reliance that if a social worker is intervening in a family's setup, calling unannounced, looking at what's happening, that they are doing that in order to safeguard the child, not to leave them somewhere where they are obviously being injured. And of course it doesn't fit neatly into the reliance in terms of the conversations in Headley Burn, but it is something that has to be investigated as to who is relying and what are they relying on, and why isn't there reliance? What is a social worker doing if it's not for someone to rely on them doing the job properly? And that's the difficulty with all these situations, that doing the task at all is in order to help protect children. That's the role of child protection. And to say that there isn't an assumption of responsibility or reliance by the children whose welfare is being looked into is, in one sense, very curious. Because what else is it being done for?
Going on with your map, we then have three authorities of which you don't cite any passages.
My lord, no, I've just tried to put them in chronological
Yes,
order.
X and Hounslow is mentioned somewhere, isn't it? Is it in?
Yes, X and
It's
Hounslow.
either mentioned by the judge.
It's
In this case,
It's also, it is
or is it
mentioned
in
CN and
DFX?
Pool.
It's in
mentioned
Poole.
in CN
Okay,
and Pool.
all right.
As,
But we won't go. If you don't want us to look at anything, we won't go there. Woodland.
Woodland is just the difficulty with preliminary issues, which I think is not a proposition I need to support.
No. So then we come to Michael.
That explains what I was seeking to take from Kent and Griffiths, that there were two routes to there being a duty of care in the ambulance case, one of which was assumption of responsibility, and it's just paragraph 81 makes that point, that you didn't need the assumption of responsibility, but it was there in
The other one is what?
in the judgment.
So there are two routes. One is assumption of responsibility, and the other is.
That they are like they're part of the health services, because the act that sets them up is the same that sets up midwifery services, and therefore the argument was for the claimants, that they're just part of the health service.
And therefore liability.
I'm not with you. Are you talking about Michael?
Yes.
Well, Michael was a different case, wasn't it? This is where there wasn't liability, where the victim called the police to say
Yeah.
she thought.
But all I'm saying is that at paragraph 81, the reason why in Kent, the fact that in Kent and Griffiths there was liability is explained by the two rules,
Okay, so that's just
including...
so that's only relevant for you because it explains Kent and Griffiths.
Yes, and that Kent and Griffiths is also an assumption of responsibility case. And the reason we say it's a helpful assumption of responsibility, it's helpful when analysed as an assumption of responsibility case, is that the person who relied was not the subject of the injury. The person who relied was the doctor who made the phone call, like the person, the informer in the child abuse cases, not the patient who was having an asthma attack. So you don't have to have specific reliance by the person who causes the injury. It may be an obvious point, but it is well made by that example. And it is said when looking in some of the judgments, when looking at assumption of responsibility and reliance in the context of these cases, that the child doesn't rely and the parent doesn't rely on behalf of the child because the parent is at odds with the child. And all we're saying is reliance can be whoever's wanting something done about it, and can also be implicit reliance.
So now we come to Robinson, do we?
And Robinson is really relevant only for our purposes because it's the starting point for Lord Reid in his analysis of. So we've just referred to those paragraphs where that analysis, and because it's so heavily relied on, I thought it's right just to point to those paragraphs.
Tab 18.
Tab 18. Paragraph 35 is...
And this is the passerby who's injured in a police arrest of a drug dealer.
And it's just making the point that there are certain circumstances in which public authorities, like private individuals, can come under a duty of care to prevent the occurrence of harm, so that it is not ruling out, it is not saying it is only where they cause the harm that there can be the distinction that was made in CN and Poole between not making things better and causing the harm is again not a bright light or an absolute. You can still assume responsibility not to cause harm, as well as assume responsibility in circumstances where you cause the harm.
All right, well, somebody presumably on the respondent's side has marked passages on 615. That's where he's explaining Caparo.
Yes,
But
I think is
you're relying on the passage at 616, which he then goes on to cite, doesn't he, in full, I think. So this is where he's talking about the Tafaris and Steele analysis. Is that right? Is that where we are?
My lord, yes. It's just the point to where that comes from when
He gets
Lord
round to
Reid
it later on.
refers to Robinson as being the modern law of negligence, as it were.
Yes, that's right.
So I'm just pointing to those passages and the fact that it's not just when I really am nearly at the end.
No, I follow what you're doing. So you're right.
In terms, I'm then coming at last.
You've reached Poole.
It's being said
All over,
to end
all over the country, and now we've ended up in the south coast.
what?
We're going to St Helena next. Our travels are not over yet, but we'll stick at Poole for a bit, shall we?
My lord, yes, I would just, obviously, there are, your lordships have, and my lady have read this and are familiar with it, but there are only a few passages that, and whilst much of it is marked,
Yeah.
but there are passages that I think it's just helpful for our purposes to draw attention to. The first is at paragraph 65. The passages that are marked, obviously, the parties think are all highly relevant, and probably the whole case is highly relevant, and I will only
Well,
take.
I think we. I don't know. You're both. Well, just be all of you. Not sure about Mr. Levinson, but all of you. The rest of you are all in it, along with various interlopers from the family division. So, paragraph 25, he starts talking about relevant developments to the law. He being relevant developments to the law of negligence. Then there's
I was going to start at the end of paragraph 56 on page.
Well, you're missing out quite a chunk of what we're doubtless going to be taken to. I'm looking at 28, for example. Are you going to just leave not say anything about that? Or?
This is part of the section headed on page 516, relevant developments in the law of negligence. So this is part of the history that's set out in this judgment. And it is simply setting out that there are circumstances in which public authorities can owe a private law duty.
Okay, all right.
And including
Part of the reason, if I've seen, or if I've seen a little irritated to go through this, forgive me, Miss Campbell, because we have been through the exercise you've engaged in is very much what Lord Reed was engaging in this, which we've all read carefully.
But I know it's aggravating, and I'm afraid it happens in all of these cases. I said to my learned friend as I came into court, here we go again round the houses in terms of the authorities, because we've both been involved in this exercise from Exton and Bedfordshire onwards. And
Yes,
it has
well, we know who to blame then, don't we?
a roller coaster, and I do apologise, because I know it's aggravating,
No.
but there are passages
right.
which...
So you say, whilst not ignoring what Lord Fawkes wants to look at, you say let's focus on 57, do you?
I'm starting with the summary from D&E's Berkshire, and I think we haven't put in the authorities bundle the D&E's Berkshire in the House of Lords, but there is a convenient summary there as to what happened
In 58.
in the House of Lords. That there was, and that was always part of the argument, that D&E's Berkshire was good law, and despite X and Bedfordshire, that the House of Lords had looked at the Court of Appeal decision in D&E
But it
Berkshire.
doesn't help us in this case. That's another side issue. It's not going to tell us what Poole decided that's relevant here, Ms Campbell. There are lots of things. We could go to lots of sentences, and they're all of tremendous historical interest. But that doesn't help us. It's not this case.
Well, we're trying to see from and Poole what help we can get into what circumstances would or would not amount to assumption of responsibility, and it is difficult to identify the circumstances except by reference to the general proposition.
Okay, well, paragraph 65, is that where we really
5.
focus? 65 on 528?
Please, my lord, yes. And that's because that still seems to remain controversial as to whether local authorities, the circumstances in which local authorities will owe a common law duty of care. And that leads into the discussion on assumption of responsibility.
The 65 isn't controversial. It's the law.
My lord, yes, but it is still argued, as it was in DFX, for example, that...
Well, we're bound by 65. I don't care what anyone else says. It's above our pay grade to change 65. That is the law, isn't it? So we know the public authorities don't generally owe duty of care to prevent people from suffering harm, but they may do so if, in the circumstances, they've created a source of danger, as in Bournemouth, where they brought the boys onto the site, or where they've assumed responsibility. That's the law.
My lord, yes.
And the question is whether or not, given what DFX has said about which facts do and don't fall outside it, whether your facts are analogous to DFK and whether DFK is arguably wrong. I don't understand what's wrong with 65, or even if there is something wrong, how can we say it's
I'm not
controversial?
suggesting there is anything wrong with it. I'm suggesting
I
it
thought
does
you said
set
it's
out the law.
controversial.
Sorry,
it
I'm
doesn't
not...
matter. I thought you said it was controversial, as if in some way it didn't reflect the law, but it is the law. Anyway, we've got 65 now.
And then from 65...
Well, can I, at the risk of interrupting you again, forgive me, it's assumption, this is the key phrase, is it? We can forget about creating the source of danger, but it's assumed a responsibility to protect the claimant from harm.
Yes.
Yes.
That is what the responsibility is.
Yes.
Those extra words possibly will feature prominently in what you're going to say.
My lord, yes. And that it isn't just where they cause the harm. They may assume responsibility to protect from harm, which means the third party...
I mean, it may, again, it's me being slow, no doubt, but that... Right, and then we come on to the section when Lord Reed talks about this. Again, we're covering stuff we've already covered, Headley Burn. X. Barrett, Phelps.
And then I just point to paragraph 69 because I made something of it in relation to Lord Brown Wilkinson in X and Bedfordshire saying that they weren't providing professional services to the claimant. Lord Reed explains in paragraph 69 that they may be.
Sorry, I'm not with you. What do you say about 69? 69 appears at the start to be against you, that generally social workers were held not to have assumed responsibility towards the claimants in charge of these cases on the basis they weren't providing their professional services to the claimant, and it wasn't reasonably foreseeable that they would reply on reports which they provided to their employers. What are you saying that says that helps us?
I'm saying that it's explained in that paragraph that it isn't the case in a blanket way that social services can't assume responsibility towards claimants because they're employed by social services, which is what appeared to be being said in...
What about, if we put a line through that, what about the earlier bit then? Are you or are you not saying that there's something wrong about those sentences? Social workers were held not to have assumed any responsibility towards the claimants in the child abuse cases on the basis that they were not providing their professional services to the claimants, full stop. Is that or isn't that a helpful indicia of whether or not there is or isn't an assumption of responsibility?
It is no longer the test as to whether they're providing services only to their employers.
No, that's why I put a full stop there, Miss Gumbel. So I've asked you to imagine a full stop after the word claimants in the 5th line. I'm asking whether the words in front of the full stop, which don't refer to employers, is or is not an indication that's relevant to whether or not there's been an assumption of responsibility.
Well, it's true that in Exon beds they were held not to have assumed responsibility, but it doesn't mean that they never can now.
No, but as a general indication, it appears to be saying that the starting point seems to be that they don't provide the services to the claimants, and you shouldn't treat that, the provision of services, as an indication of assumption of responsibility. Or is that a wrong reading of the first 4.5 lines?
I would say the correct reading is that the reason in Exon Bedfordshire, one of the reasons in Exon Bedfordshire why it was found there wasn't a duty of care was that Lord Brown Williamson took the view then that if you were employed by a local authority, you were only providing services to the local authority and couldn't be providing services to the child as well, whereas subsequent cases show that that is not the full analysis of the situation.
Is it possible that instead of putting a full, looking at 69, the first sentence in 69, instead of putting a full stop after claimants in line 5, it should be read as putting the word therefore after the word and? Is that?
What you see it means, yes.
Well,
So in other words, because they weren't, well, you see what I won't spell it out.
all I'm saying, I'm sorry, I'm not making it clear.
Well, so what if I could perhaps interrupt for a second, Ms Double. What Lord Reed is doing in this section of the judgment is discussing the cases in which the concept of assumption of responsibility has been considered, and that review includes many of the cases you referred to this morning. And at 72, he summarises his conclusions, which include correctness of these decisions not in question, but the dicta should not be understood as meaning that an assumption of responsibility can never arise out of the performance of statutory functions.
Yes. Whereas in Exon Bedfordshire, because of the...
But he's not, as I understand it, casting any doubt on the analysis in those earlier authorities, except to the extent that that proviso applies. But I might be wrong. That's how I read that passage in the judgment.
Then you go on to 73, and the end of 73 says clearly the operation of a statutory scheme does not automatically generate an assumption of responsibility. So the operation of the Section 17 or the Section 47 Children's Act scheme doesn't automatically generate an assumption of responsibility. And then we have to move on to the what else is there on the facts of your case, particularly in the light of DFX, does bring about, arguably.
My lord, yes. But
That's
it
the
is...
point, we haven't got there yet.
But it is...
We're getting closer though. Again, can we just, having rushed you now, I'd just like to slow us down a little bit on Paul. So, after his analysis of the previous authority, he gets in 74, Miss Gumbel, doesn't he, to his point that Exon Bedfordshire is the point at which he says it's no longer good law. Lord Reed says it's no longer
My
good
lord,
law.
yes.
So far.
Insofar as it's ruled out grounds on public policy.
And instead, the law begins with the word whether.
Yes, it depends on, which is why I went to Robinson briefly, that's
Yes.
where the new age law in Lord Reed's terms begins, is the principles in Robinson, which is why I pointed to the passage that there can also be an assumption of responsibility where you're preventing harm as well as whether you're causing it.
And I underlined before, when I was preparing, I underlined that part of paragraph 75, beginning with about line 8 or 9, that approach, by letter B. And the second half of paragraph 75. Is that
My Lord, yes,
important?
the reference to Dean Berkshire and the fact that because the argument had been in the Court of Appeal and accepted by the Court of Appeal in CN and Poole that Dean East Berkshire had been overruled by the case of Michael. That was the main argument in the Court of Appeal, which was upheld, which is why this decision upheld the Court of Appeal on different grounds.
Yes, and that's the importance, the different grounds. You've got to look at the pleaded facts, and they said the pleaded facts didn't give rise to liability, and it seems that the starting point is that there's no general assumption of responsibility simply because they're operating a statutory scheme, such as Section 17 or Section 41, and there was nothing over and above the general scheme to cause liability, and that's what you've got to focus, not on all the things that have gone before.
I know, yes, I appreciate that, but I still say that there's not very much help here as to what will be assumption of responsibility in the child protection cases, which is why I thought it's helpful to see how courts had looked at the child protection, the need for child protection cases to get why eventually the position was reached where the child protection cases could give rise to a duty of care, whereas initially in 1995 they'd been found never to be able to.
Again, just from benefit of my note, the passage of where it is clearly established what the correct course is, I think, is 82. It's possible.
Yes, that's the
But and in particular, line 4 on 535, the sentence beginning nevertheless.
The previous claim must provide some basis, and if you read 81 as well, what I'm having trouble in Scumble, I keep saying, is 81 says there was investigation and monitoring. That's what Section 17 and 41 involved in this case. There had been complaints by various people, if you go back to the facts earlier described, or the pleadings earlier described, and none of that was enough, it seems. So you get some help from Poole alone if you read the description of the pleadings earlier in the case in paragraphs 81 and 82, and you may get even more help from DFX if that is not arguably wrong and the facts in your case are similar. And aren't those the most helpful passages?
But the fact was, and that appears from the reference to the email, that these functions were not being carried out under the Children Act.
No, that's not correct. That's one bit. But if you look at paragraphs 11 and 12 and following, that's where the amended particulars are set out. There was reference also to the email, which was thought to be of help to one of the parties. But you've got to look at all of it, because these are the particulars that are summarised, particularly paragraph 12. And in the middle it says the Council is said to have accepted a responsibility from the claimant's difficulties in proportion to investigate the risks and in attempting to monitor their plight.
But on the facts of that case, this was about damage to the children by the neighbours, not the home situation.
Absolutely, the context may be different.
And what I was referring to on page 535, between B and C, where they're looking for where there might be an assumption of responsibility on the facts in that case, reference is made to an email written in June 2009 in which the Council's antisocial behaviour coordinator, and this is who was involved with this, Amy being the mother, we do as much as is in our power to fulfil our duty of care towards you and your family, and yet we can't seem to be getting it right as far as you are concerned. But the email does not appear to have been concerned with the council's functions under the 1989 Act.
Yeah, that's one factor, but
Yes.
it's not the sole thing that they refer to as not established responsibility. The case wasn't simply based on that one email, was it?
My lord, no, but it is of interest that it is important under which functions the local authority was carrying out investigations in the CN and Poole case.
It
Because,
was only under section 41, wasn't it?
well, the investigations weren't the as to whether to take the children. There were never investigations as to whether to take the children into care, because, and as rightly pointed out by Lady Justice King in the Court of Appeal, there never would have been care proceedings where the mother wasn't the cause of the injury.
So was the reference to sections 17 and 47 of the 1989 Act in the pleading, as per paragraph 11 of the judgment of Lord Reed, a red herring? Was a matter of analysis.
Well, the distinction is that we were pleading that they should have been carrying out those investigations in order to remove the children, and the findings were that they weren't carrying out those investigations under the Children Act for the purpose of care proceedings, because there never could have been
That was
care
the case.
proceedings.
That was the further reason why
Yes.
you gambled. Surely that's not a fair reflection of Poole. That was an additional reason why not.
Lady Justice King's reason.
Yeah, but surely the judgment read fairly and as a whole was saying that in this context, the investigation into the claimant's plight, i.e. the looking into what had happened and what they could do to deal with them, did not involve a duty of care such that failure to act under section 17 and or section 47 arose. It wasn't because they couldn't take them action against the mother, it's because those factors relied on in the pleadings didn't demonstrate anything over and above a statutory scheme being operated.
We
There
would
was a
say,
statutory scheme being operated. That's what I'm not really following. What functions was the council exercising in this case?
well,
If it couldn't take the children into care on the basis that the neighbours were engaging in antisocial behaviour, what functions was the local authority exercising?
well, because one of the children had cerebral palsy, they were on the child at risk register as a child in their area who was at risk because he had severe physical disabilities, and that was the context of that. But what I would say in response to that is that although on the facts of this case, the section 17 and section 47 investigation didn't amount to an assumption of responsibility, that doesn't mean it never can do.
No, I
No,
agree.
no.
We understand that.
We're
We've
at
been saying that now
cross
for
purposes, I
2.5 hours to you. The question that we've been asking is, if your facts aren't different from DFX, and if DFX is not arguably wrongly decided, what on your facts are different? Because all you refer to so far is matters brought to the authority's attention by a variety of people, and investigation and monitoring. And those appear to be the sorts of things that they're talking about as the facts in the pleadings didn't begin to establish a duty of care. That's the problem that I've got with what you're saying.
Well, that's the difficulty of looking at these cases on strikeouts, because until you look at the detail of what the local authority did in terms of intervention, and if assumption of responsibility is as specific as there's got to be, for example, a specific conversation in which somebody says, I will look into that, and somebody responds, that's good because I'm really worried about it and I trust you to look after it, that is not going to be revealed until the social workers are cross-examined.
According to you look at the pleadings, which we haven't looked at yet, and you identify the paragraphs that you say are the something else on top of the section 17, section 41 or 47 duties, which gave rise to it here. That's the exercise you've got to do. And if we can go further, because as I keep saying, you haven't answered the question, if the facts are the same as DFX, and unless you can show that DFX is arguably wrongly decided, haven't you then failed to establish There's something extra.
The facts in every case are going to be different, and the detail.
You can't strike out any case then.
Well,
You can't.
we would say they're not suitable for decision on strikeout because the facts, if assumption of responsibility is so fact sensitive, until you have the social services records before the court and the details of what was said in terms of what investigation would take place and what steps would be taken to protect children, until you know exactly what happened, you can't
strike
say
out,
whether there's an assumption of responsibility.
And you could strike it out in pool. The Supreme Court could strike it out in pool simply because the context was different. Is that it?
Because the context was different,
Okay.
and there was the second reason is not completely irrelevant. It would have been struck out anyway as not being a child protection issue, and the facts where the children are not at risk at home.
So in other words, the statutory framework that was relied on in the pleadings didn't support an argument that a duty of care was owed, precisely because the aim at which the statutory framework was tending was taking care proceedings, and care proceedings would never have been taken in this case on those facts.
My lady, yes. And it's only by taking care proceedings and removing from the situation that you would have avoided the harm, because you couldn't, and the difficulty is that you couldn't argue that they had an obligation to rehouse, because that is an area in which the courts have found there isn't a duty of care on local authorities for policy reasons. So there were only two routes to safety for these children. It was either being rehoused, which couldn't be insisted on in civil proceedings as a duty to rehouse, or taking the children into care away from their mother, and you were never going to justify removing them from their mother, even though they were at risk living in the house with their mother
Because the risk wasn't from the parents.
because the risk wasn't from the parents, so you wouldn't have justified care proceedings on that basis. That was the difficulty with the Aaron Pool.
So the rehousing point is, what was the first point about rehousing? I follow the second thing, never going to justify care proceedings.
That you couldn't bring a civil claim based on a failure to rehouse, that because of Mitchell and X and Y and Hounslow and various other authorities that don't give rise to a duty of care in the housing functions of the local authority.
But I thought, I'm looking now at 18, I thought that this was twofold, but paragraph 18, I thought it was one, services under section 17 which can include accommodation in respect of children in need, and section 47 which is set out at 22, whether there was reasonable cause to suspect that a child is suffering, is likely to suffer harm, to make such inquiries as they consider necessary to decide whether they should take any action to safeguard or promote.
But
There is both section 17 and make inquiries under section 47. That's what was the allegation. They didn't do either of those. And if they had done, they might have put them into different accommodation.
and it was found on the facts pleaded in that case that they hadn't assumed responsibility to do either.
Yes.
And that was clear from the context of these children not being at risk from the family, but needing to be rehoused effectively.
So you say neither of those grounds apply here. We're not dealing with a housing case, and in both of these cases, care proceedings could have been taken.
My lord, yes, and should have been, because here there were very specific allegations, which it was, well, in the YXA case, there is a specific allegation about a child, and I will come to the...
Yeah, we'll come to the facts.
We'll come to the facts.
Well,
I had only...
should we try to get through your map by the end of
My lord, yes,
short journey?
there's only one other case, and that is just the Airport Authority case, which makes the point that the local authority in this case is the only person who can exercise protective obligations, and
Okay.
and we cite that in the in the skeleton
Okay.
argument.
Now, are you going to refer to DFX?
My lord, I wasn't going to because we say this court shouldn't rely on it as being correctly decided on the facts.
Or do you say it was wrong? Do you go further than that? Do you say we should
Well,
say it was wrong?
my lord, yes, but we didn't appeal it on the basis there was no finding of breach of duty. So the findings in relation to whether there was an assumption of responsibility became irrelevant as far as appealing the decision as being wrongly. If it said, well, you didn't appeal it and you could have done.
No, I'm not saying that. It would help me to know why you say DFX was wrong. Are you saying DFX was wrongly decided, and on the point that's relevant here, and if so, on what basis?
We are saying that the correct decision would have been that there was an assumption of responsibility on the DFX. But
It was wrong to find there was no
assumption of
assumption of responsibility.
And are you going to flesh out that submission and tell us why? Why?
Because on the facts of DFX, there was a bespoke assumption of responsibility in terms of getting the Rayside report in order to find out whether the children were safe with a Schedule 1 offender, finding that they would be at risk as they came towards their teenage years, and then ignoring that when the children came to an age where they would be.
Can I say, I think for all of us, this is going to be quite an important point, how we should deal with DFX.
My lord, yes.
Because on one view, it could be argued that if DFX is rightly decided, that's the end of this appeal. It could be said. But,
Well,
or at least one of the appeals. So, I, for my part, I'd like to look at DFX in quite detail. I see it's 3 minutes to 1. I think, Ms. Gamble, if I may say so, rather than, I think what I'd like to suggest is that we look at this after you and Ms. Levens have had chances to reflect in the light of what's happened this morning, what you want to say about DFX.
my lord, yes, certainly. I mean,
2 o'clock.
the answer to if DFX is right, we wouldn't have a claim, in simple terms would be, but DFX was decided on the facts of that case, and it was a full trial, and the facts of that case, the judge found there hadn't been an assumption of responsibility.
Yes.
Here we're in a strikeout situation where we don't know what the details
But that's why
facts
you need to
will be.
look whether the pleaded case,
My lord, yes.
not the fact that you have disclosure, but the pleaded case, which is what Poole looked at, gave rise to any prospect that there would be a different result. So you have to look at DFX and show it is arguably wrong, or you have to look at DFX and your pleaded case to see whether what you are saying is such that it's saying no more than DFX, or whether your pleaded case has at least the germ of something different from DFX. But it's not enough to say, well, they had different social services reports because that was about DFX and this is about XYA. That isn't how it works, according to Poole.
My lord, now, obviously appreciate that, and we will come to the pleadings. and
Okay.
I'm sorry, it's
All right. So
been a bit of a detour.
what I'd like to do now is rise and resume at 2 o'clock. And at that point, I think it would like to hear initially your further thoughts or submissions about DFX.
My lord, yes.
Thank you very much.